Hello, everyone. This is Jerry Turbeville. I'm coming to you for Unit CR 325, Judicial Process, and this will cover chapters 7 and 8, excuse me. We'll go ahead and get started since we have a lot of slides to cover in this. A prosecutor must review both the facts and the law applicable to a case when he or she decides which charges best fit. Once the charge is brought, the prosecutor must focus on how to prove the allegations against the defendant. You also have to remember prosecutors may have as many as 20 or even 100 cases on the next trial docket. Those are many pages long, and there are a lot of people, especially in district court, which are usually your misdemeanor type cases. Oh, there are 5 or 6 pages of names on there, and it may end up being several hundred people that the district attorney prosecutor has to look through. So they'll do a roll call at the beginning of court, and it's quite extensive. However, in a felony type situation where there's going to be a jury trial, a lot of times that may be the only trial that's going on that particular week in a county like Avery, because it's just so difficult to get the jurors in there. If it's a really serious case, they will usually block the entire week off for the one. Prosecutors also have to decide which cases should be disposed of by plea bargains and which cases are likely to go to trial. A lot of that depends on the defense attorney, and of course, the defendant too has a say-so in it. You can't force a plea on them that they don't want. Certain defense attorneys are known to be willing to bargain for their client, try to work out the best deal they can, while others, choose to go to trial and fight, hoping that they can prove their case in front of a jury. There's also maybe a financial element involved in this, motivation there for the attorneys, because usually they get more money if they go to trial and actually fight in front of a jury, make their arguments there. However, it's also a lot more work. So it just depends on the nature of the attorney and what they like to do. That plays a big, big role in this, in addition to the prosecutor. A plea bargain is essentially a contract between the prosecution and the defense in which the prosecutor agrees to recommend a lower sentence than he or she might ordinarily recommend in exchange for the defendant entering a plea of guilty. And critics claim that the current plea bargain system forces the defendant to choose between two unattractive alternatives: pleading guilty to a crime they did not commit, or being found guilty and receiving a harsher sentence. There's also a specific procedure involved in entering a guilty plea. When a prosecutor has worked within the system for several years, he or she can often make an educated guess about which cases will demand a jury trial and which will plea out. That's very common. Usually the prosecutor, if they've been around the block a few times, they know what cases are going to go to trial and what actually aren't. And they can kind of give you the heads up if you'll touch base with them on the people that you have charged. If you're ever in the law enforcement end of things, you can touch base with the district attorney and they can say, yeah, you better get ready for trial on this one. And in a couple of months, we're going to be going in front of the jury with it. So that gives you at least a chance to prepare. The burdens of proof. There are several presumptions, inferences, and burdens of proof that a prosecutor must consider before beginning a trial. The prosecutor must present evidence and testimony to establish each and every material allegation against the defendant, and to do so beyond a reasonable doubt. In a criminal trial, the burden of proof is always on the state to prove the defendant guilty beyond a reasonable doubt. This burden never shifts to the defendant. And that goes back to our constitutional, the ideal of someone being innocent until proven guilty. The state must prove that you're guilty first. The prosecution must also contend with presumptions and inferences that protect the defendant and that also serve to shield the defendant unless the state proves that the defendant is guilty. In criminal cases, defendants are presumed innocent until proven guilty. In practical terms, this means that if the state presents only a mediocre case and doesn't persuade the jury, the jurors must define the defendant not guilty. An inference is an assumption that may be made from facts. Juries are often told that they may infer that witnesses are telling the truth or not, unless some party shows evidence to the contrary. An element refers to a material factual allegation against the defendant that, when taken together with other material allegations, constitutes a crime. The prosecutor must prove that the crime occurred within the jurisdiction where the case is being heard. In preparing for trial, the prosecutor must consider who will testify and what each witness will say. The prosecutor must also consider what evidence will be used in trial to prove that the defendant is guilty beyond a reasonable doubt. In preparing a witness for testifying, the prosecutor is not allowed to tell the witness what he or she must say. Instructing a witness to answer a question in a specific way is known as coaching. Instead, the prosecutor must ask the witness what he or she will say on the witness stand. I've gone through several preparations for trial where the attorney has had me present when he brought in a witness or a victim of a crime and had them actually sit in an empty courtroom up on the stand. No judge or anyone else was there, and would simply say, "These are the questions I'm going to ask you at trial next week." And he would go through them, or she would go through them, and let the witness get comfortable with those questions, and would say, "Now, how would you answer this?" And that way the attorney knew, or the district attorney knew exactly how the witness was going to answer each particular question. But it is not appropriate for the district attorney to say, "Hey, it would be better if you answered it this way, if you said this or that," or instead of saying that he did this, then say he did that. Those things are not appropriate and is basically should not be done. The prosecutor cannot suggest to the witness that he or she change testimony to help improve the case against the defendant. The prosecutor may take the witness to the courtroom days before the actual trial just so the witness can see the layout. Again, that is common. Prosecutors subpoena everyone involved in a criminal case: police, technicians, experts, and civilians. I used to get subpoenas on a regular basis. As court was coming up, I would get several subpoenas for the cases I had. Especially the more serious the case, the more likely I would get a subpoena. Even if I had told them that, "Hey, I'm going to be there, no need to subpoena me," they still would just do it as a matter of course. Prosecutors routinely investigate their own witnesses just to avoid any nasty surprises. There are many resources available to investigate anyone, including social media like Facebook and other sites. They can evaluate a person for credibility, and it involves many factors, including just a general feel of the person. Does he or she seem believable? Do they have disagreeable character traits? Are they arrogant or self-important? If someone really gives the impression that they're going to appear arrogant and that they may be lying or something like that, then they may be very careful about putting that person on the stand, and they may limit how much they use them, if at all. One of the most disagreeable types of witnesses is the confidential informant or a co-defendant who has worked out a deal with the government in exchange for testifying. Again, that weighs on a jury's mind if they have that information, that this person that's saying he witnessed this other person commit a crime was there with him or her. Basically, they cut a deal. And, they're trying to get out of trouble by saying this. So that immediately puts a big question mark there on whether or not this is believable. And that's understandably so. Prosecutors may also review all the physical evidence that will be used at trial prior to the defendant's to prove the defendant's guilt. Along with exhibits, the prosecutor must determine which witnesses will testify about each exhibit. Again, if we have seized something, if a person had, say, a weapon in their car and they were caught with that weapon and they had just committed an assault or something like that with that particular weapon, then that weapon will be put into evidence, and at trial it will be brought in. It will be packaged up. There will be a chain of custody where each person that's had access to it will have signed, and at some point, the prosecutor will likely put a number on the item and say, to the judge will say, Your Honor, I submit this as Exhibit 1. And, it will be a big part of their case, actually. I've had many, many exhibits that have been added to trial over the years, everything from photographs, documents, obvious evidence as far as drugs, paraphernalia, things of that nature, weapons. So, there are many things that can be made an exhibit at trial, and that's a very common way that, as particularly a superior court felony level trial, will go forward. An expert is defined as a person whose knowledge, training, or experience would help the jury or judge understand a complex issue. Again, depending on the judge, some are very, very careful and very limited on who they rule as expert witnesses, while other judges are more free with that and more willing to allow people to be called experts in front of the jury. Again, these are people that there's a vetting process, usually in front of the judge, and a lot of it has to do with how many times in the past the person has testified as an expert witness. For instance, there's a lady that works in a nearby county who is a nurse, and it's called a SANE nurse, SANE, and it has nothing to do with her mental capacity, but it's a sexual assault nurse. And she's considered an expert in her area because she's had probably more training than anyone on this end of the state and has done this for 40 years. So she knows what she's talking about by certain wounds and how those wounds appear or do not appear in certain circumstances. So it's very easy for a judge to rule her as an expert because she's got this long history. She does an excellent job testifying and has done it many, many times. And she can tell the judge, I've testified 43 times as an expert witness in various trials. So that will allow most judges to say, if all those other judges in 43 different trials said you're an expert, then I'm going to agree you're an expert. And it's very easy for her to get qualified as that. However, if it's your first time becoming an expert witness, then you may have to hope that the judge will look at your education. If you have a master's degree or a doctorate in a certain field, then you can sometimes be qualified as an expert based upon that. If you've written articles, or if you have empirical articles that you can quote on this particular subject, then the jury will and the judge will a lot of times give that more credit, because you're not just stating this as a fact from your knowledge. You're standing on the shoulders of other people saying, well, these folks with PhDs did this study and they discovered this, and then in another time it was repeated and this group discovered this. And if you can continue to do that and use empirical studies, then that kind of bolsters you as an expert witness. When a party presents an expert, they must first go through the expert's training, education, background, and then tender the person to the court as an expert. This background questioning is referred to as qualifying the witness. Essentially, physical evidence is some relevant item that tends to prove or disprove an element of the crime. Demonstrative evidence, however, refers to charts or diagrams used by the attorneys or witnesses to help illustrate or explain testimony. Demonstrative evidence sometimes is used in civil trials. I've seen it before when one person's suing another, the insurance companies are suing back and forth because of a vehicle accident where someone was severely injured at an intersection. And a lot of times they'll have maps and, detailed drawings, charts of showing where the vehicles were and who made the mistake in traffic, so that the jury can understand it by looking at that. It's now quite common for prosecutors and defense attorneys to digitize all the media involved in a case and store it on a flash drive or computer so that it can be pulled up with much greater ease than the traditional hard copies held in files and storage cabinets. PowerPoint presentations are now a routine part of all closing arguments. This is very true. While I wouldn't say it's on the cutting edge of advanced technology, these have all been around for quite a few years now, but the courts have always been slow to adopt new technology. So, they want to be very careful that it's not junk science and they're getting something that's really useful. But commonly, all of our media has been digitized. It must be on a DVD to play in court. It's been a long time since I've seen the old VCR rolled in front of the jury and an actual VHS tape put in and played. But that goes back quite a few years. But that used to be the way it was done, and that was considered advanced technology back then. But now it's common to see PowerPoint presentations, especially if it's a confusing case, toward the end at closing arguments. We'll go into Chapter 8 now. Defense attorneys represent people who have been charged with a crime. There's the public defender system, which is an appointed system with an hourly rate or a flat fee. The public defender system basically are attorneys that are on a rotating list that a judge can pull their names out and assign these attorneys to people who cannot pay for one reason or another. The attorney-client relationship is created when three specific events occur, none of which actually involves the payment of money. First, the defendant goes to the attorney and seeks advice or help in a case. This is true, and it creates a conflict if that attorney later it tries to represent someone else in the trial that's against the benefit, I guess you would say, of the other person, the person that has come to them first and talked to them. So basically, if you go to an attorney, even before you paid any money, and ask them how much they would charge for this particular case, you give them the details, then that attorney, there's an attorney-client relationship, even if no money ever changes hands and you decide to go hire a different attorney. The advice or help sought is clearly within the scope of the attorney's expertise. And third, the attorney agrees to take the case either by expressly stating it or by implication, such as starting an investigation into the case or contacting the prosecutor on the defendant's behalf. The defense team does not have the resources available to the government. The first source of information about the case is the client. Defense attorneys routinely contact police officers and other witnesses to discuss the case. This is not unusual. The defense attorneys have contacted me hundreds of times over the years and just said, tell me what my client did here and why you charged him. And most of the time, they're not there to argue with me. They just want to know what I saw, what I have. And, a lot of times, they trusted my veracity enough that I was able to tell them, I said, look, this person did it. It's obvious. Here's the information. We have plenty of evidence. And then the attorney will go back and talk his client into pleading guilty because he sees that there's just no way he's going to win a trial. So that is very common. Pretrial motions. Once the defense attorney has sufficiently investigated the case and reviewed any material provided in the case, he or she will undoubtedly file motions concerning the case. One example would be a motion to request state witnesses speak with the defense attorney. It's not raised in every case, but the attorney might file such a motion when he's running into active resistance from police officers or other state witnesses, because normally officers are under no obligation to talk with the defense attorney, and if they keep letting their calls go to voicemail and never return them, and the attorney feels like they're being stonewalled, then they can actually have a judge order that the witnesses talk to them. Defendants are under no obligation to present any evidence of any kind. If he does, he must present some evidence to support his defenses. Among the many affirmative defenses are self-defense, alibi, consent, and insanity. Individuals who testify for the state are there to help prove the elements of the offense, but witnesses who appear for the defense are there to establish evidence for a particular defense, attack the elements offered by the state, or to create reasonable doubt about the defendant's guilt. The final decision about what and whom to believe rests with the jury. It's the jury's duty to decide if a defense is valid and creates a reasonable doubt. If a defendant presents a defense, the state's required to disprove it beyond a reasonable doubt. Defendants must prove their defense to a preponderance of evidence. In other words, their standard is lower. If they can show, based upon the evidence, that their client very likely didn't do this, then that's enough to take the case down from a reasonable doubt level to a point where they shouldn't be convicted. There are simple defenses, which are those legal or constitutional defenses that all defendants have and do not require evidence to prove, such as presumption of innocence. And then affirmative defenses require the defendant some evidence to support them. For instance, an affirmative defense like an alibi, you may have that person who is your alibi or those people who are your alibi come forward to court and say, no, he couldn't have done this at that time because he was with us. Many jurisdictions allow defendants to present inconsistent defenses, no matter how inconsistent they are. Defendants are required to notify the state when they intend to bring a certain affirmative defenses, such as an alibi or insanity. The defendant's required to serve written notice on the government. With insanity especially, that requirement, basically the defense will provide usually a forensic psychologist that they are paying to check the defendant out. And if the forensic psychologist said this person was not sane at the time that the crime was committed, then that will give the state an opportunity to use a state forensic psychologist, have them examine the person, and basically if they come out and say that, hey, this person is sane, he was sane at the time, and that's nonsense, you simply paid a forensic psychologist to come up with this conclusion, and we disagree with that, then a lot of times a judge can rule that no, that isn't going forward because there just isn't enough there to say that they were insane at that time. I have seen certain cases where insanity defense was brought forward. It is not always successful. As a matter of fact, it's usually not successful. However, if a defendant does come in with a long history of mental health issues, and I'm not talking about minor depression or something like that, I'm talking about institutionalized for periods of time in their life, then usually those, a judge will agree that they have some serious issues and will very likely rule, if the forensic psychologists agree and testify to that fact, that this person has issues. And I'm talking about severe schizophrenia, and certain other issues. So basically, it's got to be serious mental health disorders, not something that's relatively minor, and there has to be a history of it. And then usually the judges will rule for that fact. The government's required to present evidence rebutting the affirmative defense. If the prosecution fails to rebut the evidence, then the defendant is entitled to a directed verdict in his favor. Now, in this section, we will discuss specific types of affirmative defenses. Age. In most jurisdictions, a child below the age of 7 is presumed to be incapable of forming mens rea, and that's the criminal mind, the thinking of, oh, this was a crime and I'm going to do it even though I know it's illegal. An alibi. An alibi is a defense that asserts the defendant was not present when the crime occurred. Alibi does not admit to the underlying crime and then seek to mitigate or excuse it like many of the other defenses. There's also a defense called battered woman syndrome. It's a legal defense. It's an offshoot of self-defense and allows a battered spouse or significant other to retaliate against repeated abuse at a time when the person is not being attacked. Sometimes this is referred to as the burning bed syndrome. I don't know if there was an old movie many years ago called The Burning Bed, where in the movie a battered wife actually set the bed on fire with her husband asleep in it. So that is, again, just part of battered woman syndrome. Coercion is the affirmative defense that alleges that although the defendant committed the crime, he was forced to do so by someone else. I saw this one actually used successfully because it was a criminal enterprise where a house was burned down by a team of guys, and they were directed by like a sort of crime boss, if you will. And he had something against this new house that was being built. They didn't use his particular contracting crew, so he was angry because he wasn't getting any money out of it. So he forced a couple of guys to go up there and burn the house down. And of course, they were caught. And then they admitted, hey, he made us do it, man. He was holding some stuff over my head, and I had to do it for these reasons. And basically, he was able to show that it actually was the crime boss that was responsible for the crime, and not so much him. And I think they were able to work something out in favor of this particular defendant because of that. When a defendant raises the affirmative defense of consent, he or she is saying that the victim agreed to the crime and therefore there can be no crime. Again, it's rare, but I suppose there are times when a victim agreed to crime and they can raise that as a defense. A claim of duress is one in which the defendant claims that some other person used intimidation, psychological control, or other means short of outright threats to force a defendant to commit a crime. Duress operates as a mental manipulation. Entrapment. The defendant claims he was tricked or manipulated into committing a crime by the police. Did the idea for the crime originate with the police? Did the police provide the defendant with the means to carry out the crime? If the answer to both questions is yes, then the defendant has been entrapped. I remember a famous case. It was actually a federal case called, referred to as Ruby Ridge, where Randy Weaver was I guess you would call him a prepper or survivalist that lived way up on this mountain with his family. And he had quite a few guns, and the government was becoming very suspicious of some of his motives. So the ATF went to him, an undercover ATF agent, and asked him to saw off a shotgun for him, which is a federal crime. And he told him no originally, but then a little later, he got in a tight spot for money. And again, they approached him the next time and said, hey, I'll pay you this much money if you'll just saw off the shotgun for me. And by the way, here's the shotgun. And so they provided him with the shotgun, which is the means to carry it out. And Randy went and sawed off the shotgun, and there ended up being a huge standoff at his compound. And at the end of the day, they ended up having to pay him a significant civil payout, and everything was kind of squared away. But I think his wife did lose her life, maybe one of his kids too. It was a horrible situation anyway, but one of the issues that came up in trial was the fact that he was actually entrapped to sawing off the gun. Insanity is one of the most complicated and often misunderstood defenses. A defendant who raises the insanity defense must admit that he actually committed the crime but was legally insane at the time it occurred. If the defendant was legally insane, then he or she is incapable of forming mens rea. The McNaughton test is one of the most famous tests used in this particular branch of defenses for insanity. And it was an early attempt to establish a workable scheme to determine who was and who was not legally insane. The test created in that case had been adopted in one form or another by many states. The defendant was insane if he did not know the difference between right and wrong at the time he committed the crime. In most states, the modern definition of insanity is either the standard of the McNaughton test or some other variant of that. Did they know the difference between right and wrong? There are really two different types of insanity pleas. The defendant may be insane at the time of the crime or insane at the time of the trial. The defendant who wishes to use the defense of insanity must serve notice on the state prior to trial that he or she plans to do so. This notice allows the state to bring in its own experts to evaluate the defendant. The defendant who raises the defense of insanity must present enough evidence to establish by preponderance of evidence that he or she is insane. The defense of diminished capacity allows a defendant to offer testimony and evidence about his mental condition. This evidence is intended to mitigate or excuse their guilt in the crime. A defendant can be found legally insane even if he knew the difference between right and wrong. He was unable to control himself from committing the crime. Voluntary intoxication is not a defense to most crimes. Involuntary intoxication can be a defense. I had a case once where a gentleman was fed pills. Basically, they spiked his drink, put some pills in it, and I suppose they dissolved. And he drank it and became very, very impaired with just one drink, almost to the point of passing out. And later we were able to prove exactly what happened. But again, he was involuntarily intoxicated at that point. Involuntary intoxication results when a person is overcome by fumes or chemicals to such an extent that he is no longer capable of rational thought. Again, this is a different type of situation where maybe they didn't do it on purpose. Maybe I've heard of plumbers working in a confined space with some of the glue that they glue the PVC pipes together and becoming extremely intoxicated from the fumes. When a defendant raises the defense of a mistake, he is saying that although he committed the crime, he was not aware that it was a crime. When a defendant agrees to enter into a fight, he essentially surrenders his right to bring charges for battery against the other fighter. When a defendant claims necessity, he admits that he committed the crime, but in this case, he did so in order to avoid some catastrophe or some force of nature. In other words, if you and a friend are out hiking somewhere, become stranded in a heavy snowstorm, a blizzard in your vehicle, you get out of the car because there's a cabin up on the hillside. You walk up there, there's nobody home, it's locked up tight, but you kick in the door because you're going to freeze to death if you don't, then that's a crime of necessity, and the courts will look at that. It would be very unlikely that you would be charged with anything. Under the law, a person always has the right to defend himself against a physical threat. The response of the person raising the claim of self-defense must be comparable to the threat. You can't, a threat that's just, for instance, a fist fight with someone that's either smaller or the same size as you and not, roughly the same age and not in some fantastic shape or a black belt martial artist. If everything is somewhat equal, then you can't rise to a higher level, I would say, and go to a firearm because, physically the two were equal. So there's less of a chance of that. However, if a person is gigantic and, a black belt and they're going up against a really small person and there's just no chance that the small person is going to be able to defend themselves on that level, then they may have more of a standing to resort to a higher level of force. A defendant cannot use the defense of self-defense when he or she is the person who started the fight. Individuals who are trained in the martial arts or are professional fighters or have advanced military training may be considered to be using deadly force even when they respond with their bare hands. The state has the burden of disproving one or more of the elements of self-defense beyond a reasonable doubt. The state must present evidence to rebut the claim. Defendants have come up with a wide variety of novel and interesting defenses. These novel defenses have rarely been successful. The Fifth Amendment provides numerous protections to a person accused of a crime. The Fifth and 14th Amendments require that all citizens be treated fairly. People falling into different socioeconomic, religious, and racial categories cannot be treated differently under the law. The Due Process Clause requires that the same procedures be used in all criminal cases. The Fifth Amendment prohibits a person from being tried twice for the same crime if that person was found not guilty in the first trial. The defendant may challenge the statute under which he or she has been charged by claiming that the statute's worded in such a vague manner that people of common intelligence would have to guess at its meaning. A bill of attainder is a legislative action attempting to short-circuit a criminal trial and declare an individual guilty of a crime, usually treason. An ex post facto law is one that criminalizes behavior or increases punishment for an action after it's already occurred. There are several factors that weigh against putting the defendant on the stand. If the defendant testifies, he would then be subject to cross-examination by the prosecutor. Most of the time, the defendant does not testify. I've seen it, and it doesn't usually work out well for the defendant, although in rare cases it does. Under the Federal Rule of Criminal Procedure, and many states are the same, the moment that the defendant takes a stand, the defendant can be cross-examined about his criminal record. That's it for the presentation. That covers those two chapters, and have a good week and good luck with the rest of the class.